Welcome to the webinar presented by the Office of Court Administration, or OCA, on the Judicial Council Monthly Court Activity Report submitted by county clerks. My name is Sandra Mabbitt, and I am the Judicial Information Analyst at OCA, where our mission is to provide resources and information for the efficient administration of the judicial branch of Texas. First, I'd like to give you an idea of what the Judicial Information Section at OCA does. Our section is responsible for working with clerks and courts in collecting, analyzing, and publishing the court activity statistics for the more than 2,700 courts in the state. We also publish and maintain the Texas Judicial System Directory using the information gathered from each of the individual courts. In addition, we are here to provide assistance to various court staff as well as the court's case management vendors and local information technology staff on report guidelines and submissions. Now, today's topics will include some background information on the reports, hopefully providing you with a better understanding on why you do the reports. I will also discuss reporting, covering the reporting requirements, as well as going over some important case category definitions. First, let's get started with some background information. The Texas Judicial Council is the policy-making body for the judicial branch. It consists of 22 judicial, legislative, and citizen members. Since it was created by the legislature in 1929, one of the primary duties of the council has been to gather statistics from judges and other court officials, and it is the only entity that collects comprehensive statistics on the operation of the Texas courts. The council determines what data will be collected on the monthly report, and OCA collects the statistics on behalf of the council. The statute that created the Judicial Council requires that the council collect statistics from judges and other court officials, and it authorizes the council to require statistical reporting from judges, clerks, and other court officials as a duty of office. The Judicial Council's reporting requirements are detailed in Chapter 171 of the Texas Administrative Code. The Texas legislature also mandates that certain information be reported to OCA. The legislature has created statutes requiring clerks to report information on human trafficking, involuntary mental health commitments, and hate crime findings. The reports primarily capture information on the court's inputs, that is, cases filed, outputs, adjudications or dispositions, and pending caseloads, which are the basics of any court data collection. Like any other reporting or measurement system, the reports cannot possibly capture everything that the courts do. The Judicial Council reports provide information about the nature, scope, and volume of work before the courts, and it is used by all levels and branches of government and countless other interested entities and individuals to assess court workload, performance, and needs, and to identify and analyze trends, including identifying emerging problems, develop solutions to address the problems, and evaluate whether the solutions are working. Now let's move on to the reporting requirements and other information on submitting the reports. Our Reporting to OCA webpage has information that is very helpful for preparing and completing the report. At the top of the Texas Judicial Branch webpage, select Judicial Data, then Reporting to OCA. On the Reporting to OCA page, select the Judicial Council Trial Court Activity Reports link, then select District and County Court Reports. Here you will find the form and instructions, as well as answers to frequently asked questions. I would recommend that you bookmark this page and save it as a favorite so that you can easily access it in the future. The page also offers XML specifications and an XML tester that can be used by your IT staff or case management system vendor to set up your reports so that they can be uploaded to our database. This eliminates the need for you to type the data into the report on our website. Another very useful tool found here is a spreadsheet with DPS codes classified by OCA case category. This will assist you in determining where a particular violation should be placed on the reporting form. The report instructions define what should be reported in every line and case category on the report. You should use these instructions as your first resource in determining what should be reported where. You should also check the website periodically for updates, especially after a legislative session when the instructions and lists of DPS offense codes are updated. When we make an update to the instructions, the changes are highlighted so that you can easily identify new material. Note that you are required to submit the report online unless you have a waiver from reporting online from OCA. Waiver requests must be submitted in writing. If you have any questions on whether you qualify for a waiver, please contact our office. OCA has no authority to grant a waiver that would excuse a clerk or court from submitting reports. Chapter 171 of the Texas Administrative Code requires the monthly report to be filed no later than 20 days following the end of the month reported. So, for example, the report for July's activity is due by August 20th. Now, there may be times when you won't be able to submit the report by the 20th and maybe a couple of days or even a week late. That is fine, and there is no need to contact us. But if you are going to go several weeks or months and unable to report, please contact our office to let us know. However, you do need to be aware that any grant funds that your county is eligible to receive from the Texas Indigent Defense Commission may be withheld for noncompliance if your reports are not complete for the state fiscal year. Each county clerk is required to submit the Constitutional County Court Activity Report unless the court has no judicial functions. Those clerks who have responsibility for maintaining any records for the county courts at law must also submit a statutory county court report. The activity for the Constitutional County Court and county courts at law cannot be combined into one report. Court activity must be reported for the court, not by judge. It does not matter which judge is sitting on the bench of the court. In addition, credit should be given to the court that disposes of the case. For instance, if a district judge is sitting in the county court at law for the day, the county court at law gets credit for the cases. If the case is filed in the district court but heard and disposed of in the county court at law, the county court at law needs to get the credit. If assignment of the case to the county court at law is automatic, the case management systems will need to be able to credit the filing and disposition of the case to the county court at law. If the case is first docketed in the district court, then sent to the county court at law, the case should be reported as disposed of by transfer in the district court, then reported as a case added in the county court at law. Transfers between the same type of court, district court to district court, or county court at law to county court at law, should never be counted on the OCA report because the report is intended to provide a county-wide snapshot of the activity at a particular court level. Reports must be submitted each month, even if there is no activity to report. So you must ensure that all sections of the report are submitted where the courts that you are reporting for have jurisdiction, again, even if the courts had no activity to report in any one or more particular section. If the courts you are reporting for do not have jurisdiction or do not hear certain types of cases, you may leave the section blank, or you may submit a no activity report if you wish. So, for instance, if there is no juvenile jurisdiction, you do not have to submit the report. However, if you choose to submit a no activity report for this section, you must continue to submit a no activity report for each month, as once a section has been submitted in one month, it must be submitted in each month. Another requirement is that you keep copies of the reports that are run from your case management system for a minimum of 2 years. Now, don't confuse that with keeping a copy of the report once you have submitted it to our website and then print it out. Also, if you manually prepare the report because you don't have a case management system, make sure that you keep the report and any backup information to support what you submitted to our website. Now, I'll discuss using this report in the review process in the separate webinar on the actual submission, review, and correction of the reports. Now let's talk about the nuts and bolts of the report, that is, the content. I'll begin by going over some definitions, the first being pending cases. The definition of a pending case is a case file that does not have a final judgment. A final adjudication has not been made. Most sections carry forward pending case balances from the end of one month to the beginning of the next month, with the exception being the hate crimes, probate, and mental health sections, which do not carry pending case balances. Pending cases are separated between active cases and inactive cases. The total number of pending cases should equal the active pending cases plus the inactive pending cases. So let's go over the difference between an active case and an inactive case. Active cases are those cases awaiting a judgment that the court is able to move to disposition. In other words, there is nothing keeping the court from moving the case to a final judgment. Inactive cases are those cases awaiting a final judgment that the court is unable to move to disposition for reasons that are out of the court's control. Now let's go over a few examples of inactive cases. Some examples of situations where a criminal or juvenile case should be inactivated are when a defendant or juvenile has absconded and an arrest warrant or directive to apprehend has been issued, when a defendant or juvenile is committed to a mental health facility, or when the defendant or juvenile is being held elsewhere on state or federal charges. In civil and family cases, some examples include when a case is ordered to arbitration and all further proceedings in the court are stayed, when a notice or suggestion of bankruptcy or suggestion of death is filed, and when a stay is granted delayed due to the Soldiers and Sailors Civil Relief Act. For additional examples of inactive cases, please refer to the report instructions. The next definition I will cover are cases reactivated. Report a case as reactivated when both the following have been met. The case is currently reported as inactive, and further court proceedings and activities can now be resumed because the situation that was present causing the case to be considered inactive is no longer a factor. Now a final judgment may be entered in the case. Always remember that a case that has been reported as an inactive pending case must be reported as reactivated prior to it being reported as disposed of on the report. Also remember that a reactivated case should be reported under the same case category reported when the case was originally filed. This rule applies to the case from when it is a new case filed, made active, inactive, or reactivated, and also when the disposition is reported. You will report the case as reactivated on the date the warrant is executed or the date of the defendant's first hearing. You should use the event for which you have the best information. To help you in determining what status to report a criminal or juvenile case as active, inactive, or reactivated, I would suggest that you refer to and print out the flowchart on the next page. With the use of the inactive and reactivated statuses, the calculation changes for determining the age of cases disposed. When a case is made inactive, the aging clock stops. The clock starts again when the case is reactivated. So as shown in the example on the screen, the use of the inactive pending status during the 30-day period between when the defendant absconded and they were apprehended and returned to court made the total age of the case 120 days rather than 150 days. As we previously discussed, the pending cases are forwarded from the end of the month to the beginning of the next month, and theoretically should be the same. However, there may be instances where they do not match for various reasons, such as cases were not processed or updated in your case management system prior to the last month's report being run, or corrections were made to cases that have been reported in previous months. To account for those differences where the cases pending are not equal, a docket adjustment must be entered to account for that difference. Keep in mind that docket adjustments are meant to account for minor fluctuations in the pending cases. At times, larger adjustments may be necessary, and we'll discuss those in just a moment. You will not find the docket adjustment line on the form. It is only found in the online reporting system. So let's talk a little more about what causes docket adjustments to perhaps help you avoid these in the future. Docket adjustments to increase balances are usually caused by new cases not being entered prior to a report being run, while those made to decrease balances are usually caused by dispositions not entered prior to a report being run. You may be able to avoid docket adjustments for these reasons. Remembering that the report is not due until the 20th, one way to avoid them may be to set a day of the month, perhaps the 10th or 15th, when all cases must be updated in your case management software system, and then run the report after that set time frame. While this won't guarantee that you will never have a docket adjustment, it should greatly assist in reducing the need to make them. Now, there are instances when large docket adjustments are necessary, and that's fine. However, they must always be accounted for in the notes section at the bottom of the report. There are common reasons why you may need to make these type of docket adjustments, with the most typical being when an audit or validation or manual hand count of your cases is done, when you convert to a new case management system, when you enter dispositions and disposition dates for cases in your system that have been closed but had not been updated in your system, or when you purge cases where the statute of limitations has expired. To make the docket adjustments, there are simple rules to follow. To increase the number of pending cases, simply enter that number you wish to increase the category by. Do not use the plus sign. And to decrease the number of pending cases, use the minus sign and enter the number you wish to decrease the category by. Now, continuing with some guidelines for docket adjustments, you should never enter the numbers that you want the pending cases to be in the docket adjustment line. If you do this, you will essentially double the number of cases that you report as pending because it will be added to the number of cases pending at the end of the previous month. The next few screens will illustrate an example of this. In this example, you can easily see that rather than making the adjustments to the numbers properly, the numbers they wanted the pending cases to be were entered. So let's look at the categories where docket adjustments were made. In the motor vehicle category, instead of placing a -4 in the docket adjustment line so that the new cases pending would be 2,275, they placed 2,275 in the docket adjustment line, making the new total 4,554. And in the eminent domain category, instead of placing an 8 in the docket adjustment line so that the new cases pending would be 99, they placed 99 in that line, making the new total 190. You can now see that in the motor vehicle category, a -4 has been placed in the docket adjustment line so that the new cases pending correctly shows 2,275, and in the category of eminent domain, an 8 has been placed in the docket adjustment line so that the new cases pending correctly shows 99. When you make the docket adjustments, you should review the active and inactive cases line numbers. The number that you increase or decrease by will automatically increase or decrease the number of active cases. If adjustments are needed, you will make the necessary changes to the inactive pending cases, which will in turn correct the active pending cases so that again the two total the new pending cases. Now let's discuss the criminal and juvenile sections of the report. If the case lists more than one offense, classify the case under the most serious offense. The reason for this practice is to give the court and clerk office credit for the more serious case, which may involve more resources devoted to that case. If the offenses are equal, it does not matter which category you choose to classify the case. For the juvenile section, cases should be classified into the appropriate category based on the offense. Delinquent conduct cases should not all be reported under all other offenses. Remember that for purposes of the report, the case must stay in the same original case category through the entire process. New case filed through disposition. So even if the prosecutor reduces the charge or the defendant is convicted of a lesser or different offense, you will still report the disposition under the same category that you reported it as a new case. You must keep a one-to-one relationship between filings and dispositions. Now, in the instance where the report has already been submitted and the case has been recategorized to a more serious charge, you should run another report from your case management system and correct the report in our reporting database, which will place the case in the correct new category. For statistical purposes, a case is considered disposed when the defendant or juvenile is placed on deferred adjudication, deferred prosecution, probation, community supervision, or pretrial diversion because the case has been adjudicated. These cases should be reported at the time the defendant is first placed on the program. If the defendant or juvenile complied with the terms of the agreement, nothing further will be reported on the monthly report. However, if the person does not comply and a motion is filed to bring the defendant or juvenile back to court, the case gets reported on the motion to revoke line of the criminal report or on the motion to modify, enforce, or proceed line of the juvenile report. A disposition will then need to be reported for that motion. When cases are transferred from another county for probation, the transferring county reports the disposition. The county the case is transferred to will not count the case on the report unless a motion to revoke, modify, enforce, proceed, etc. is filed to reopen the case. In the Sentencing Information Section of the Criminal Section, you should only include cases that you reported under the Conviction section of the report. We commonly see instances where the total number of cases disposed are included in the Sentencing Information Section. So, for instance, when the judge finds the defendant guilty with a sentence of probation, you report the conviction by the court as the disposition and probation in the Supplemental Information Section. In cases where the defendant was placed on deferred adjudication, you will report that as the disposition and nothing will be reported in the sentencing information. Remember that each case should be reported in the same case category as the original charge. For example, a case in which a capital murder charge was reduced to murder should be reported under the capital murder case category. In addition, report only one sentence per case disposed by conviction. And last, report the sentence that the defendant was given, not what the defendant actually served. Similar to the criminal section, only the cases reported as adjudicated with finding of delinquent conduct or CINS in the juvenile section should be reported in the disposition section. None of the other adjudications reported should be included in the disposition section. The hate crime section is required to be submitted each month if the courts have criminal jurisdiction, even when there is no activity to report. Article 2.211 of the Code of Criminal Procedure requires the clerk to report any case in which a motion is made for an affirmative finding where an offense was committed because of bias or prejudice. The report must also indicate whether the affirmative finding was entered in the judgment in the case. So, if you report criminal activity, ensure that you also submit the hate crimes report. If there is no hate crimes to report in a particular month, simply click on the No Activity box, place your name in the Prepared By line, and click on Submit. For those county clerks who may handle probate cases, be aware that if you are reporting new cases filed in the independent or dependent administration or guardianship categories, you should also be reporting inventories filed, guardianship of person reports filed, and annual or final accounts filed where appropriate. These documents are required by law to be filed in those cases, and usually within a specific deadline. If you have cases filed in your county but have no cases reported in these categories, it means that you either have a reporting problem or that the court is not fulfilling its legal obligations. Pay special attention in the Additional Information section for guardianship cases. For cases dismissed or denied, granted, and closed, you should report activity for the month only. However, the number of active guardianships should reflect all open cases in which a guardianship has been established for as far back as you can provide information. With the reporting of the active guardianship information, substantial issues with old, open cases have been revealed. To get an accurate number of active guardianships, you should clean up your old cases and get them closed. The judge can remove cases from the active docket in one of two ways. If relevant to the case, the judge can sign an order removing the case from the active docket for failure to file a final account or report. The order must cite either Section 1204.201B or C of the Estates Code. If those sections of the Probate Code do not apply, the judge can appoint a successor guardian to file the final account and close the case. We are now at the end of the webinar, and I wanted to make sure that if you have any questions, you have our contact information in Judicial Information. The email address is one that we all monitor, and the first one that sees an email will answer you. The main number for OCA is listed, as well as a fax number that comes directly to our section. Feel free to contact us with questions or concerns at any time. Thank you for taking the time to view this webinar. I hope that you find it helpful in the completion of the monthly court activity reports.